open up the hearing on Assembly Bill 158. And I know that I think we have someone who is on the phone who will also be testifying if I am correct. And so welcome, Assemblyman. And whenever you are ready, you can feel free to begin.
Well, thank you, Madam Chair, and members of the Judiciary Committee. Thank you for having me this morning. I'm honored to present Assembly Bill 158 for the record. Assemblyman Tom Roberts from Assembly District 13 in Clark County. This is Mr. Hambrick's, Assemblyman Hambrick's bill. He's unable to present. He's still dealing with family emergencies, so I'm here on his behalf. First, I'd like to just start with a brief introduction. Then I'll turn it over to Mr. Dodd, who's going to be a co-presenter. He presented this bill in the Assembly with Mr. Hambrick. He also has someone on the phone, as you mentioned previously, and then we'll open up for questions. So basically, Assembly Bill 158 is about ensuring that our youngest inmates should be able to successfully reenter society. It would allow the courts to depart from mandatory enhancements and reduce a mandatory minimum period for incarceration for that person. Basically, it just allows some options for judges for individuals that were under the age of 18 that were the victim of sex trafficking or sexual abuse. To further explain the bill and go over the details, I'll turn it over to Mr. Dodd.
Thank you so much. James Dold for the record. I represent Human Rights for Kids, which is a Washington, D.C.-based human rights organization. Let me just note at the outset and thank Assemblyman Roberts for presenting the bill on Assemblyman Hambrick's behalf. And I just want to send a quick note to Assemblyman Hambrick, wishing him and his wife a speedy recovery, and our thoughts and our prayers are with them. Human Rights for Kids is dedicated to the promotion and protection of the human rights of children across the United States. Central to our work is elevating the discussion around adverse childhood experiences and early childhood trauma and their relationship to negative life outcomes for children, especially for children involved in the justice system. For far too long, we have ignored, in the conversation around criminal justice reform, the most vulnerable casualties of mass incarceration in America, and that is our children. And perhaps there's no better instance of injustice than when we're dealing with child sex crime victims who've committed acts of violence against people who have previously sexually abused, raped, or trafficked them. AB 158 seeks to rectify this injustice in the law. I'll go over briefly the dynamics of the legislation, and we'll talk about why this bill is so important. On page 2 of the bill, we have legislative findings, which talks about the need to treat child sex crime victims, particularly child victims of sexual assault, sexual abuse, or sex trafficking, as victims, even when they commit acts of violence against people who've perpetuated harm against them. It's important to note that this bill does not require judges to do anything except in the instance when they're dealing with these particular types of victims, they're authorized to depart from any mandatory minimum or suspend any portion of an otherwise applicable period of incarceration. And that's only after the judge finds that by clear and convincing evidence, which is a very high standard, that the child victim was in fact victimized by the person who they committed the crime against within 1 year prior to the commission of the offense. So again, it's a very high burden for the child victim to meet, but if a judge does in fact find that the person was victimized by the victim in the case, then they will be authorized to suspend any portion of a sentence or depart from any otherwise applicable term of imprisonment. Later on, you're going to hear from Sara Kruzan, who really inspired this case, and I won't go into the details of her case because I want her, for you all to hear her voice directly. But Sara is not alone in being a victim of these grave sorts of injustices where excessive punishments have been imposed on child victims. And many of you may have heard of the case of Cynthia Brown. Cynthia Brown earlier this year received a gubernatorial pardon from Governor Haslam in Tennessee. She had received what was in effect a life without parole sentence for having killed a John who had picked her up and was attempting to rape her. Cynthia was a 16-year-old child sex trafficking victim who had a very violent pimp by the name of Cutthroat. This was a young girl who had been victimized. She had been raped, tortured, beaten, and the justice system's response in a case where she had committed a crime against somebody who was attempting to rape her was to impose a life without parole sentence. Similarly, Alexis Martin, another young girl who's currently serving a life sentence for a crime that she committed against her rapist and trafficker in the state of Ohio. She was 15 years old when her trafficker was killed. This is a far too common occurrence in our justice system. One of the things that the bill lays out in the legislative findings is that there's a significantly high number of girls who are victims of sexual abuse at 1 in 9, and boys at 1 in 53. We know from the National Center for Missing and Exploited Children that rough commercial sexual exploitation every single year. It's important to note that in the instances of these cases, one of the things that makes them very unique, particularly in the context of sex trafficking, but also when we're dealing with child sexual abuse, is this dynamic of traumatic bonding. This is where a child goes through a process of grooming. They have sort of embedded themselves in the child's DNA, acting like a friend, gaining the child's trust, and then betraying that trust and sexually abusing that child. What ends up happening in these instances is that the child develops this misplaced sense of loyalty. And that traumatic bond is a very difficult thing for the child to break. And oftentimes children will feel that the only way out in those situations is to commit an act of violence against them, to get away from their trafficker. In the testimony, abuser, and he had been abused for a period of 4 years, and one day acted out when the man tried to sexually abuse him again. He ended up stabbing him 56 times. And in that case, thankfully, we saw the prosecutors go after a lesser charge of manslaughter, and the judge actually didn't impose any prison time. Unfortunately, that's not what happens in a lot of these cases, as you'll hear a little bit later on. Many of you may be wondering, well, why under the law wouldn't a self-defense claim be adequate? And one of the problems with the current self-defense statutes in this regard with these particular types of cases is that oftentimes the child victim needs to show that there was an urgent and pressing danger, that the act of violence that was committed was necessary to save the person's life or prevent significant bodily injury from occurring. And oftentimes in these cases, these children act with what the law would regard as premeditation. That is, they'll plan the act out and they'll commit a crime against the abuser. And so what we're saying under this is that even in those instances, we need to take into account the fact that this was a child victim of sexual abuse. An otherwise applicable term of imprisonment that might for somebody else under different circumstances isn't appropriate for a child in these particular circumstances. It's our position that what's happened to girls like Sara and Cynthia and Alexis is nothing short of a human rights abuse. The idea of imposing a life sentence on a child who commits an act of violence against somebody who was previously sexually abused or sexually assaulted or sex trafficked them is nothing short of a human rights abuse. Nelson Mandela once said that there's no keener revelation of a society's soul than the way in which it treats its children. Children victims deserve our understanding, our empathy, and our love. They don't deserve to be demonized and thrown away by the justice system. And what we're asking this committee to do, which is what the Assembly did earlier in this session, is to send an unmistakable message to child victims like Sara and like Cynthia and like Alexis, and to say to these child victims, we see you, we hear you, we will protect you, and we love you. And with that, I'll go ahead and close out my testimony and turn it over to Sara so you can hear directly from her what this bill means to her and why a policy change in this direction is so important. Thank you.
Yes, I can hear you guys.
Okay, you can go ahead. We can hear you. So you can go ahead with your testimony.
Okay, thank you. My name is Sara Kruzan, and I just want to say thank you to the Assembly and also to the members of the Senate for this opportunity to share. First, I would like to say that I'm 41 years old, and it was 25 years ago that I inflicted violence upon my trafficker and took his life. The fact that I look at it as, I'm a mother today, and I look at it in hindsight, the fact that it's taken 25 years for an opportunity to have policy brought about and the conversation shared amongst people to change policy makes they just don't have enough to give anymore. And I say that because even though my life growing up with my mother in this space was extremely violent, extremely horrific, in school I excelled. So I had this idea and this belief that I would become a pediatric surgeon. I wrote books in the fourth grade about drugs and its effects, and I was inspired by my mom's behavior, right? Like what I was watching, and bringing it to the forefront in a creative space. And I didn't understand what was happening to me as the continuous trauma was being imposed in my life, from the physical violence to the mental abuse to the confusion in race. For me, this was going on in my home. And to set the background, traffickers look for victims that, fit this specific criteria. The vulnerability, being compliant, high levels of fear, and children that experience this were not able to identify what it is we're feeling. It's just we begin to show it in different forms. So at 11, I was walking home from school. My mother wasn't home, and Gigi convinced me to get in his car for ice cream. And it eventually led to being at his home, where there was this gentle imposition of luring and touching and molestation, which was very confusing, with this position of being like a protector, and then he took me home, and I was so afraid of my mom's response. There was no trust because of the aggression and the physical. I felt that everything that had just been imposed and exposed to me was my fault, which only underscored my belief window at that time, which was embedded in me by my mom's inability to parent in a healthy form. My mother allowed men of various ages to come into the home. Our home was, not the most safe home environment. So boundaries were not imposed. I was exposed to my mom's sexual interactions with the men that she would have. And all this began to have a huge effect on me. And I withdrew and had times when I thought that suicide attempts would be more beneficial. In that space, the indoctrination of Gigi began to take a more intense form. It's an organized intention. Some traffickers have different approaches. Some are very calculating, and George was a very intentional and calculating individual. At the age of 12, he was already visiting my mother. So this man was engaging with my mom. There were times when I would see him hand my mother money. It wasn't unusual for me to see that from my mom because my mother had a view that everyone kind of, owed her and people were to just kind of help her, that she had a victim mentality that was not really healthy. And I don't say these things in judgment. I say them just from personal experience. And at 12, my mother also introduced a 23-year-old man into my life as my mentor. He would bring food from the local pizza place. And then my mom would say, "Take this bitch," excuse my language, "get her out of my hair." My mother, I think, fought with conflict within herself because she was come from a German-French background, and her father was very strong in his beliefs against not intermixing with other ethnicities, and there was trauma in that household as well. And my mother intentionally had children with men outside of her own race, but there was anger and resentment around that as well. And so I grew up, my sister and I grew up with being referred to as the N-words if we did not if we were unable to clean the house a certain way, or if I banged a dish unintentionally in the sink, it could make my mother have an aggressive response verbally, mentally. But again, I share this because it's the building blocks of individuals who are usually targeted for these traffickers. My grades begin to go from A's, from being on the principal's honor roll, to D's and F's. I pretty much gave up in areas of my life and was just existing. At the age of 12, with Roosevelt being in my life, my mother having him be that mentor, right, distorted my belief windows on men. There was a fear of men of color, particularly. I was, 1991, I was gang raped by 3 men in the middle of the day at my school, at the same school that I had become the student body principal. So I just had this really deep sense of hopelessness. I also know that through education and awareness, through my work capacity today, that traffickers use various tactics to break their victims as well. And examples are rapes, paying people to break a person's down even more. So at the age of 13, Gigi had created this space where he was this very distorted person in my life. And the payback of his kindness and his teachings consisted of things like this. The constitution of a marriage is BS. It's a legalized form of prostitution. You got to give something to get something. And these teachings, I believed, even though innately to my soul, they did not set well. However, my reality didn't show anything other than what I had been exposed to. And so me being compliant and not being able to have a successful suicide, the willingness to please and to be loved was so distorted that I allowed myself, or I believed that I had allowed myself to be a person who was simply just a sexual object. And that is a whole nother experience in itself, because you have people that buy a child and they have these specific requirements. And some of these individuals are people of the community. Some of these individuals hold a badge as a police officer. Some of these individuals are your dentist. Some of these individuals are your neighbor. But they look so clean cut and they are doing what they're supposed to be doing, right? They're taxpayers. They present well. They have families. But then there's this other side, this darker side of people, the shadow side I like to refer to, that people find this of, I don't know, it's like an ungodly, and a lot of times children are utilized in these spaces. The fact that I killed Gigi, it stays with me every single day. I feel that as a restorative justice practitioner to this day, I sit and I hold spaces with offenders, which I own that space, and I also sit with victims of violent crime, and I own that space. And we create a narrative that allows people to connect and have the hard conversations and an opportunity to be acknowledged, valued. It is life-changing on so many levels. I feel that violence against George was just that in the system. Because when the years that led up to it, the victimization, I didn't understand that I was a victim. I never knew that I was a victim. It wasn't until I was incarcerated, had a college degree, and began to advocate for change with policy in California that I realized that I was a victim. I had an institution I had a judge, I had the district attorney. Nobody asked me what happened. I was immediately labeled. Nobody cared about what I showed up with. I had a 2.5-day trial. I was my only witness. I had no understanding of the legal jargon that was being bounced around my head. I didn't feel that I had a right. I didn't feel that any adult in my life felt that I was worthy of a human right to live a life outside of the experiences that I had. And then on top of that, when the judge imposed his sentence, even though when I had went to the youth authority and they had saw that I had never been offered any kind of therapeutic opportunity, They recommended that for me. They wanted me to come back as a juvenile and go under a therapeutic model at that time. And the judge said no. He sentenced me to life without the possibility of parole plus 4 years. That I lacked moral scruples, and then I had to pay a $10,000 restitution fine to victim services. I've had 19 years and 7 months inside of one of the largest women's institutions to deeply think about not only what led up or what leads up to a person or a young person committing a violent act, but the responsibility of adults and how it's easier to have children carry the burdens of what the adults impose. My goal in life was to be a pediatric surgeon, not to be labeled as a murderer, not labeled or sensationalized in the media as a young prostitute. While incarcerated at CCWF, some of my peers that had also been sentenced to life sentences as youth either took their own life or died from medical negligence or resorted to drugs. These are just experiences. But I've also seen people rise and become resilient and give hope and restore what was taken. You know? I think that when we hold people accountable for acts of violence, I think going to the very core of what implements that violence creates an overall wellness for us as a community instead of being just tolerant. We can no longer be tolerant in our negligence on how we handle a person's human right to be. So this bill, to me, it means a lot, of course. It is motivating. It's inspiring. It gives people hope. It gives us who have been subjected to carry the sins of others an opportunity to stand, to rise, to be heard, and to be treated with compassion and love. So I think having the judges have an opportunity to offer something outside of incarceration would behoove us as the people that represent the United States. Because today, what I do, I'm a taxpayer. I work on advocacy. I volunteer my time. I'm a mother of a child with, I'm a mother of a beautiful child. I have friends that are just the depth, right? The depth of our friendship is amazing. The relationship. I think if we are able to have relationship with individuals, then we can be a part of the solutions.
Okay.
And I think if we take an approach that's more restorative and transformative in our efforts, then we can move forward and advance.
Okay, I think...
So I just want to say thank you. I appreciate your time. And it can't even be defined, me having an opportunity to present in front of you guys today. So I appreciate you.
Nope.
Thank you.
Nope. Thank you for your testimony. So Assemblyman, I don't know if there's anything else you wanted to present to the committee or if now would be a good time to maybe take some questions.
Thank you, Madam Chair. It will be a good time to take questions. Thank you.
Senator Orenshaw.
Thank you very much, Madam Chair. And thank you, Assemblyman Roberts. Thank you for helping Speaker Hambrick. You know, while he's taking care of his wife. And Mr. Dold, Ms. Kruzan, thank you for sharing what happened. Mr. Dold, I've heard you speak before, and I know you've commented on bills at the legislature, and you've talked about the new brain science that legislators didn't have 20, 30 years ago when these laws were being put on the books about how a child's brain develops and the understanding they have and don't have about things that they're doing, decisions they make. And I wonder if you could just briefly kind of speak about that and the new brain science we have and what it tells us about children and their understanding of decisions.
Absolutely. Senator Orenshaw, James Dold again for the record. So you're absolutely right. In the last 20 years, there has been a vast increase in our understanding of juvenile brain and behavioral development. Specifically known is that the part of the brain that is responsible for executive decision-making, the prefrontal cortex, isn't fully developed in children the same way that it is in adults. And as a result, children actually rely on a more primitive part of their brain known as the amygdala to process information and make decisions. It's one of the reasons why children are more impetuous, more susceptible to peer pressure and making irrational decisions. It's important to note that one of the things that the science also points out is that that dynamic is even exacerbated when we're dealing with children who've experienced adverse childhood experiences or early childhood trauma. So the impact and the delay in development is significantly exacerbated by that dynamic. And so I think it's important as we're looking at kids in these sorts of situations that we're focusing on the fact that they do have these underdeveloped brains, that's been exacerbated by this early childhood trauma, and that they are oftentimes sort of dealing in these situations, trying to understand, how they got there and what their way out is, and not able to make rational decisions the same way that an adult would. We have laws, and this is one of the reasons I made my comment at the beginning, is that, we're not focusing as a nation on the most vulnerable casualties of mass incarceration in America, and that's our children. We've created this fallacy that when a child commits a serious crime, that all of a sudden the distinction between childhood and adulthood completely go away. But of course, the criminal justice system was designed with adults in mind. And that's one of the key components of this law and why it's so important and why we haven't really ever focused on this before. Because, we have all these children who have experienced this horrible trauma. They have these underdeveloped brains. They've experienced, their trauma exacerbates that, and that they're making decisions in these moments, and we're holding them to the same level that an adult would. And so this bill is very much a reflection of that reality, that children aren't as fully developed as adults are, and that there's a need to have this special protection in place specifically for them.
Thank you, Mr. Dold. Thank you, Madam Chair.
Absolutely.
Senator Scheibel.
Thank you. I appreciate you guys coming in here today to testify, and so I'm going to do what I do and just jump into my technical questions, because I don't really question the philosophy or the rationale behind this policy, but my question is, reading the bill, it gives judges the discretion to either depart from mandatory minimums or suspend sentences. So is this supposed to apply at the sentence phase or during an appeal or both? How do you envision this being implemented?
James Dold again for the record. And Senator, yes, it would be at the time of sentencing. And so there are already a number of different laws in place dealing with, specifically with children, once they've been convicted of a crime in adult court. And so, for example, in 2017, the Nevada State Legislature passed a bill allowing judges to depart from mandatory minimums for children up to a certain percentage after the judge considers how children are different from adults. So this law would function in the exact same way, that the judge would take into account the information that's been presented by the defense, and if the judge finds by clear and convincing evidence that the defense has met their burden, then the judge would then be authorized to depart from any mandatory minimum or suspend any portion of the otherwise applicable sentence.
And if I can follow up, how do they suspend just a portion of the sentence?
Well, one of the James Dold again for the record. One of the things that that's sort of envisioned by this is that the entire sentence would be suspended in the event that the judge thinks that's the appropriate sentence to impose. So again, it just gives them more discretion and tools at their disposal. And again, it's a completely discretionary matter. So the judge could still say, even though I find this person's a child victim, they're still going to get the mandatory minimum of life with the possibility of parole after 20 years. But in that instance, a judge could say, well, I'm going to give you life, but I'm going to suspend all but 5. Or, I'm going to give you a term of years and suspend all of that up to a certain point. So that's the way that it would function.
Thank you. That answers my question.
Senator Dondero Loop.
Thank you very much. My question is, as the senator's sidekick over here, I'd like to know what's going to happen to these young adults. It's really great to say we're going to suspend sentences, but if we don't have some proactive transition pieces in there, they need some deeper help. So as a person who understands children, I'd like to know what's going to happen moving forward, because if you just suspend the sentence and send them out into the streets, it's the same conversation we've been having for decades.
James Dold again for the record. So, one of the things that could very well happen is that, if a child gets, let's just say, a 5-year sentence, they would be able to avail themselves of whatever programming is currently available through the Department of Corrections. I think, Senator, your point is well taken, though, that, particularly for child victims, there needs to be an increase in services and a recognition of that. This bill actually was, to your point, was amended in the Assembly Judiciary Committee because the first iteration of this bill actually would have given judges the ability to also strike the conviction and send the child back down into the juvenile justice system for treatment and services, which is the preferable model. We don't think that any child who commits a crime against their trafficker or somebody who sexually abused them should be spending any time in prison. The problem, I think, or one of the issues that was flagged was that there isn't sort of a current service model available for children in the justice system that would adequately address all of those needs that you highlight. And so, in this instance, what we're trying to do is just say, if the judge finds that this was in fact the case, let's not exacerbate the situation worse by having this person serve a life sentence, but let's, give them an opportunity to come home sooner.
Follow up, Madam Chair. So I hear what you're saying, and I appreciate what you're saying, but there's a funding model to this. And I know that this is a policy committee, but if we're stripping the services out, if we're going to hang our hat on this bill and help these children, we need to fund and we need to be proactive in how they get services. And so I would encourage those who have hung their hat on the bill to fund those services. Thank you.
Senator Pickert.
Thank you, Madam Chair, and thank you both for being here. Mr. Dold, I appreciate all of your efforts on this bill and previous bills similar to this. I was an early adopter of this order as part of the probation, some of the therapeutic opportunities that are available, so that we're not just kicking them out on the street and say, okay, go figure it out on your own, but as a measure of as a condition of probation, they're getting services. Would you please get into that a little bit?
Yeah, absolutely. And so James Dold again for the record. And this goes again to giving judges greater discretion, and this is why it's such an important bill, is that when we fully restore a judge's ability to make the right decisions in these particular circumstances, they can come up with a more just outcome. So one of the things that very well could be a condition of a suspended sentence is, that they would go through a services model. I know that, Judge Voy, for example, in Clark County, he does a really great job. Now, he deals primarily with kids in the justice system, But again, the model is getting those kids treatment and services who've been victims of child sex trafficking. So it's definitely an important component of this, because in order to fully rectify all of the issues that are going on, and as Sarah mentioned earlier, the need for therapy, the need for treatment, recognizing first and foremost that these kids are victims, and then, making sure judges have, we don't impose these terrible sentences on them, and then, as a condition of that as well, making sure that they're able to go through some of those treatment and services programs.
Thank you. I appreciate that. I mean, I was frankly disappointed that we lost the diversion back to delinquent or to juvenile court because it is a different type of approach. It's a therapeutic approach, trying to get kids back on track, get the services wrapped around them so that they can become good, productive members of society in spite of their difficulties in their youth. And I frankly agree with my colleague that we do need to create and fund those programs if they don't exist. I'm under the impression they do, but maybe not to the extent that was necessary to keep this bill alive. But certainly we know a lot about trauma in early childhood and what it does to rewire the brain and create in the normal in the brain of the person who's grown up in a intact family or a more favorable circumstance. So I agree with my colleague. I would be happy to work with her on a bill to make that possible. But I appreciate you being here, and thank you for letting me sign on to the bill.
Mr. Dold, you brought up a point that I hadn't thought about. You mentioned the 2017 bill that kind of mirrors the same structure. Why wouldn't that bill also apply to a situation like this?
James Dold, Madam Chair, again for the record. It would potentially. What we're saying, though, is that there's sort of degrees of culpability when it comes to even juvenile offenders. So, for example, you could take into consideration all of the different factors in a child's life, and a judge could say, I'm going to depart up to a certain percentage because, the child has shown a capacity for rehabilitation, and maybe given their childhood, they're maybe not as culpable as an adult otherwise would be. But these particular situations are much more unique than even a child who commits, a serious crime and who's been transferred into the adult system. These are kids specifically who've committed crimes against people who've raped, sexually assaulted, or trafficked them. And so even in these instances, we feel that judges need even greater discretion given the nature of the crime, given the nature of the person that they've committed the crime against, and their victimization that led up to the crime. Because essentially, it never would have happened. The child, like Sarah, Centoya, Alexis, they never would have been incarcerated in the first instance had their traffickers not raped and molested and trafficked them. And so that's sort of the recognition that we're trying to create there.
Sure, and I remember the same language, to depart from
Very
a
similar,
mandatory
yes.
minimum, or that they could suspend a portion of the sentence. And so this bill, there doesn't seem to be any sort of like a notice of witnesses or a way in which that hearing would be conducted, or any obligations to kind of know what that looks like? Or is this just, we show up to sentencing and here's some evidence of this and no one's seen it before? I mean, how would you envision that works? Because the language of this bill doesn't have any of those types of things.
Absolutely. James Dold again for the record. Yeah, we've kept it broad to give, the court, a lot of discretion in this area. But essentially, at the point of conviction, and then basically at the sentencing hearing, allowing the judge to take into account all of the evidence that would be presented, which would otherwise be mitigating factors as well. So the judges under the 2017 bill would already be required to allow that sort of mitigating evidence into account. And then this would just say that before a judge could go this far, that they would have to find by clear and convincing evidence that the person was a child sex crime victim.
And I completely understand that. I guess I'm just, if we're going, because this indicates to me that there would be some kind of evidentiary hearing to find by clear and convincing evidence, and there just doesn't seem to be any sort of parameters for when that would happen, how that would take place, if there's going to be if it's going to be a full evidentiary hearing, if it's just a submission to the judge in camera, like those kinds of more procedural things. But we can probably have that continuing conversation on that. I don't think we have any additional questions, so we will go ahead and open it up for testimony in support. If you are here to testify in support of Assembly Bill 158, either here or in Las Vegas, please come on up.
James Dold again for the record. Thank you, Madam Chair. I would just say that going back again, this bill doesn't require judges to do anything. It just gives them discretion. They can still impose the mandatory minimum, but it's important, again, when we're dealing with children in these particular circumstances, that we give judges all the available tools at their disposal. And with that, we would urge this committee support. Thank you.
Again, I'd like to thank you, for the record, Assemblyman Tom Roberts. Thank you. As you heard testimony from a lot of folks, there's a lot of other bills that are associated with this that will come through this committee. So please consider those when you consider supporting this. And if there's some minor changes that we can make coupled with the other bills that would address your concerns, we'd be more than happy to make those. So thank you and have a great day.
Great, thanks. So we will